guys, welcome to the latest episode of Malcontent Corner, the corner where I hope to share with you the various things that I've learned in the course of my daily life. This is episode 3 of my Estate Planning 101 series. If you watched episode 1, you know that covered Last Will and Testaments. Episode 2 covered Living Wills or / Advanced Directives. This next episode here is going to cover power of attorneys, and there's basically 3 different kinds. But before we get into that, as always, I am not a lawyer, and because I'm not a lawyer, and because the laws that involve estate planning and all these documents which I'm talking about vary from state to state, I strongly recommend you do not take me at my word here, and you seek out local professional legal help with regards to anything involving your estate planning. Now, in the last episode, we covered living wills and advanced directives. And one of the documents I'm going to talk about here is actually considered part of the advanced directive, but because it kind of splits the line between advanced directive and a power of attorney, which is what we're talking about here, I've decided to include it in this. Now, a power of attorney is nothing more than where you give permission to somebody else to act upon your behalf. And there are basically 3 kinds of power of attorneys. There's general power of attorney, there's special or limited power of attorney, and there are medical or healthcare power of attorneys. Now, with all of them, you might hear power of attorney or durable power of attorney. What is the difference between the two? Well, in a general power of attorney, it ceases to function if you become incapacitated. So in order to make sure that the power of attorney is still in place and valid when you can no longer act on your own behalf, you would at that point make it a durable power of attorney. That is the difference between the two. Now, the power of attorney is basically, at least the general power of attorney is, you are giving an agent or a proxy, somebody to act upon your behalf with regards to financial matters. So if you need somebody to pay your bills or to do real estate transactions or anything of that nature, sell stocks and bonds for you, that would come under the general power of attorney. Obviously, because this person will have unfettered access to your financial dealings, you want it to be somebody who is trustworthy of it. Do not make somebody, a family member, or somebody who you do not trust, your power of attorney. It is kind of an important thing, so keep that one in mind. This person will have access to all your financial dealings. Now, in addition to that, there's a thing known as a special power or limited power of attorney. And that is typically in place for, from my understanding, for short periods of time, and is very, very narrow and limited in scope. It's basically a power of attorney, but a pared down, stripped down version of it, so that the person may not have quite the full access that they normally would under a general power of attorney. I can't say I know of any incidences where such was created. I'm sure there is, but I've never known anybody that had that. But you may want to look into it if it depends upon your circumstances. Now, the last one is the medical or healthcare power of attorney. And that is an important one because, once again, it impacts your life. But basically, you are appointing a healthcare or somebody to act on your behalf of healthcare. Now, again, we covered in Living Will where you try to be as accurate as you can with the circumstances which you want to either live or you don't want treatment in. It's, again, Living Will. But healthcare or medical power of attorney gives the person basically the legal right to speak on your behalf. And that's kind of a fail-safe in case a scenario pops up that may not be covered in your Living Will. Obviously, as with the general power of attorney, you want the person to be a trusted friend or family member, and you want to basically make it clear to them what you want with regards to your health care. Now, just so you know, there is a caveat here. Even though the person is a medical power of attorney for you, they cannot contradict whatever you have written in your living will. So if you have in your living will a DNR, they cannot decide, well, I decide I want that person to have a resuscitation if they should go code on us. Nope, the living will supersedes the power in a scenario between the medical power of attorney. The living will, if there's a conflict of interest, refer to the living will. The medical power of attorney, though, will be able to fill in the blanks for situations that may arise when you are incapacitated and it's not covered in your living will. Now, the requirements for power of attorney do vary from state to state. Much like wills, much like a lot of these documents, the requirements vary from state to state. So you will have to go see a lawyer on this. Some, like much with a will, some require just a notary, some require witnesses, but it's in your best interest, much as with the living will, to have a power of attorney for health care. That will benefit you. As far as the general durable power of attorney, that is also helpful to you because that person can take care of your financial affairs. Now, in some states, a power of attorney is active the second you sign off on it. So if you want a power of attorney for somebody, but you don't necessarily want to kick in right away, that's known as I believe it's known as a springing power of attorney, in which case you set forth either a date when this when this power of attorney will kick in, say, well, I don't want anybody to have power of attorney over my life until I turn 75 years old. And at that point, you will sit there and say, upon my, on my 75th birthday, the power of attorney is now valid. Or you can also put in there that you don't want it activated unless a certain set of circumstances arise. For example, you can say you want 2 medical professional opinions that you are unable to take care of your own affairs. That is a proviso that you could put in your power of attorney. So just because you sign it doesn't mean it kicks in right away, but you also do want to be aware that it may. So ask questions. If you want a power of attorney, when does it kick in? Is there a way? Is there an easy way to revoke this? Can we set up a proviso that I have to meet X criteria of not being able to do this before this will kick in? But if you have it, as always, please leave it in a location where somebody knows where to get it. Especially, for example, as I said with the will and testament, you would probably leave a copy with your executor as well as with the local courthouse. With regards to power of attorneys, whether it be healthcare or general, you would probably want to leave a copy with the people that you have designated to act as your agent or your proxy, so that they can come up and say, I have a copy, here's the general power of attorney, or here's the healthcare power of attorney, and act upon your behalf. But that's basically all there is. Now, I'm sure there are other little gotchas, little catches, but again, seek out local professional help, and you can get it all squared away. I do think, though, it is in your best interest to have both a healthcare and a general power of attorney in your arsenal. So with that, I'm wrapping up here at Malcontent Corner. I hope you enjoyed this video. I hope it helped you out a little bit. If you like it, give it a thumbs up. If you don't, give me a thumbs down. But as always, thank you for watching. Hope to see you back here again soon. Take care. We'll talk to you later.